Welcome to another episode of Should You Take That Case with your host, Lisa Wade, your friendly neighborhood legal nurse consultant, owner of Wade Nurse Consultants, and creator of our private LinkedIn community, the Attorney Medical Record Resource Group. That is where we get all of our stellar attorney guests. The goal of our show is to be a resource for legal professionals who pursue medical cases by sharing their experience and insights as defense or as plaintiff attorneys. You can catch prior episodes at www.wadenurseconsultants.com/blog on LinkedIn and on Apple Podcasts, Spotify, Google Podcasts, and more. Now here's the host of Should You Take That Case, Lisa Wade.
Hey there, everyone. Welcome to a brand new Medical Record Monday and a new episode of Should You Take That Case? Well, you know, our goal is to be a resource for legal professionals who pursue medical cases by sharing their experiences and insights as defense or plaintiff attorneys. And I'm your host, Lisa Wade, legal nurse consultant, owner of Wade Nurse Consultants. Think of us when you have those tons of medical records to be reviewed and summarized and translated into normal human language. And I am also the creator of our private LinkedIn community, the Attorney Medical Record Resource Group. That's where all of our wonderful attorney guests come from. And we use this as an opportunity to get to know one another. And we're going to do that today with Jason Argos. But before Jason comes out, we are going to scoot over to the comment section, see if there's anybody visiting us live. Please put an A into that chat. And if you're an attorney, put a P if you're a paralegal, but put a W if you are part of a wonderful group that I am a part of, Women-Owned Law. Put a W so we know you're there and we can say hello. Women-Owned Law, it's a groundbreaking group created to connect and advance women legal entrepreneurs. So visit us at womenownedlaw.org to learn more. And I want to thank everybody that is watching us live or on the replay for taking time out of your very busy days to be with us. And I'm going to introduce now our guest, Jason Argos. Jason Argos is a senior trial counsel for Kohan and Bablove in Newport Beach, California. Prior to joining Kohan and Bablove, Jason was a partner at Burke Argos in Irvine, California, where he specialized in medical malpractice, catastrophic injury, and wrongful death. Jason is an alumni of Thomas Jefferson School of Law in San Diego, and he was recently elected 2023 parliamentarian for the Orange County Trial Lawyers Association and is the current chair of the Diversity, Equity, and Inclusion Committee for the Consumer Attorneys of California. And now I bring to you Jason Argos. There you are, Jason. I told you I'm a little tongue-tied occasionally, but we made it. Thanks for being here.
You made it. Thank you for having me, Lisa.
All right. Well, how's the weather out there?
It's actually kind of cold and gloomy. It's feeling like fall.
Oh, let me just say this. We have one person visiting us live today, Aaron Hicks. There's the Hicks Law Firm in California. Yep. Hi, Aaron.
Hey, Aaron.
All right. Oh, do you know Aaron?
Aaron and I now sit on the executive committee as of next January with Aaron. So Aaron was once parliamentarian of the Orange County Trial Lawyers Association, and he's now in line to become the president here in the next, I think, 2 years.
Excellent. Well, it's a small world. Hey, Aaron. Good to have you. All right. Let's I'm gonna ask you bunches of questions about medical records and how you manage them as part of your cases. But first, we want to know more about you. How did you get to be a lawyer? How did you get into this branch or area of law, and what keeps you going with it?
Well, I don't have any immediate family members that are attorneys. I honestly, I went to law school because I thought I wanted to be a professional sports agent. So the thought process was when I was playing football in college that after meeting a few agents that were going on to represent some of my teammates, that I could do it better than they could. And I went to law school with that premise and thought that's where I would end up. During law school, I interviewed with several agencies, and the feedback I was getting was, we don't really do interns here because we pay you to learn the business, and then you take the clients or the relationships that you've built to go start your own agency. And there's no real benefit to us bringing in an intern. And that's true at some of the smaller agencies, maybe not necessarily the bigger ones, like the ones you'd see in West LA or Century City. But some of the smaller agencies, that was kind of the feedback I got. So to make sure that I didn't, waste my student loan dollars, I tried out for the moot court team in law school and really liked it and was good at it and enjoyed it. And that's how I kind of ended up on a path to becoming a litigator and trial attorney. So there you go.
All right. Well, it sounds like you wandered into the place that's right for you.
That's exactly right.
All right.
Exactly right.
All right. Oh, let me just say real quick, there's one more attorney here with us there, Stephen Haber. Hey, Stephen.
Hey, Stephen.
How's it going? All right. He'll tell us later, I'm sure. All right, there you go. And let's just move right along, and maybe you can share with us what kind of factors go into you deciding if you should take some of these cases that come your way, or refer them out to other attorneys, or find out that it's no case at all. What do you do? Yeah,
that's a great question. I was always taught and trained that this industry in particular, medical malpractice, your success is not defined by the cases you take, but by the cases that you don't take. So for me, my strike zone is incredibly small in terms of the cases that I do take. The things that I'm looking for, we all want to say that we're the birth injury specialist or the traumatic brain injury specialist or the wrongful death specialist. The fact matter is that great facts make great lawyers. That's the reality. And that kind of plays into my decision-making process in terms of the cases that I'm going to take. So I'm looking for cases where I can explain the liability aspects of the case with ease, with kind of short, punchy one-liners and themes that I can use throughout the depositions that I take in the case, as well as mini opening and opening statement, because it's those themes that allow me to really kind of vet my veneer and determine whether or not the 12 people in the box are going to be right for my case. But those theories of liability, they start from case intake. And some obvious examples would be operating on the wrong side of the spine, operating on the wrong eye. A case I represented a young boy who was given an adult-sized dose of an anti-seizure medication that led to him developing a very severe form of Stevens-Johnson syndrome that caused him to go blind. I'm looking for like elevator pitch type theories of liability because if you really have to dive deep and dig deep into the medicine to explain your case, you're going to lose folks. And that doesn't mean that I haven't handled complicated cases or resolved complicated cases. It just means that the cases I'm looking for, generally speaking, are ones that ones where the theory of liability is easily understood and digestible. In terms of cases I'm referring out, because my strike zone is so small And because the firm that I'm now at doesn't do medical malpractice exclusively like my prior firm did, if I think that there's a case that might have some legs to it, but it's going to cost maybe $5,000 to $10,000 in initial expert reviews, I may refer that on to a firm that does exclusively med mal that I've got a relationship with. Otherwise, I'm still, I would say my practice currently is probably 60-40, 60 med mal, 40 personal injury.
Okay. So you're not afraid to refer something out that's not in your niche.
No, certainly not at all. And that's, there's enough work to go around, particularly in medical malpractice, plaintiff's medical malpractice, because there aren't a whole lot of us who do it. There are unfortunately people who take cases on that maybe they shouldn't, but there's a handful of firms who have a history of success in the medical malpractice arena for plaintiffs that I would trust my own, family member with or what have you. And we all, sometimes the client's meant for you and sometimes that client's meant for a different lawyer. And that's not necessarily a bad thing.
Mm-hmm.
So.
All right. I like that. That's good. And let me say this, when you have finally found something that is that's in your niche and all of those records start pouring in, do you have a specific kind of method or protocol that you use to dive into them to get all of the juicy nuggets that you need to prove your case?
So I started, Lisa, representing doctors and hospitals. I did that for 5 years in LA for a firm called Reback McAndrews. And, as a young associate at that firm, the way you're kind of taught and trained to work through the medical records when they come in is you always go to the discharge summary first. You start at the discharge summary first, and then you work your way in reverse chron. That's generally speaking the best way to do it, because the discharge summary is going to give you a quick summary of the initial H&P, sometimes the ED information if the patient came through the emergency department. So you're going to get an idea as to how the patient ended up in the hospital in the first place. Then the discharge summary should, if well written, summarize the specialists who rounded on the patient while they were there in terms of their findings, and then ultimately the discharge plan moving forward. Or if it's a wrongful death case, the circumstances leading up to the death. After I'm done with the discharge summary and I get kind of a global sense, like a 30,000-foot view of the case, then I work my way in reverse chron through the progress notes. The progress notes, radiology reports, pathology reports, and labs, those are going to be the most critical aspects of really any medical malpractice case. It's not until you get into the birth injury cases that you really need to dive into the nursing notes, vitals, and fetal heart monitoring strips. So I would put birth injury cases into a totally separate category than just a general run-of-the-mill med mal case. So that's how I start, and I work my way kind of in that order. And one thing I'm always looking for is, now that I've been doing plaintiff's work now for 6 years exclusively, my clients come to me all the time saying that the subsequent surgeon or the subsequent physician or the subsequent doctor made a comment to them at the bedside saying that the prior doctor, who would be the potential defendant, screwed up, right? They always say, the subsequent guy told me that he missed it on the x-ray, or that he should have done, they should have hooked me up to an IV, or they should have done a CT scan and instead they only did an x-ray and an ultrasound. They should have done this, that, or the other, right? And I go look for that subsequent treater's note. Nowhere in the note is there any sort of recognition that the ball was dropped previously. Mm-hmm. And more times than not, if I do end up filing a lawsuit and I take that subsequent treater's deposition, that subsequent treater now has counsel present. That counsel is likely buddies with the defendant's attorney. And those two lawyers have found a way to make sure that the subsequent treater isn't critical at the time of deposition, even if it runs completely afoul to what my client told me during the intake process. So I tell folks all the time, I'm like, listen, I'm really not that interested in what your subsequent treater had to say to you at the bedside, because unless they're willing to say it under oath that their lawyer sit next to them at deposition, it's of no moment. It might be helpful to the extent that we kind of get to narrow in on where the issues might be or are. But more times than not, those subsequent treaters are not helpful. So I think we've gotten way off track from where your initial question was, Lisa, but I think it goes ultimately to the main question there.
Well, it sounds like you have a method. There is a method and specific steps to how you approach these records. And it's good to have a consistent, strong method to dive in.
Right.
It lets you know where you are in terms of medical treatment. So is there anything that you find terribly puzzling, bothersome, or frustrating about reading, dealing with, or managing medical records? Any pet peeves?
Pet peeves would be, I don't know how this happens, but the defense seemingly has unfettered access to complete sets of records from different facilities. So an example would be, I just settled a wrongful death case recently. The decedent spent a month at Cedars-Sinai before he passed away. And Cedars-Sinai had in total approximately 32,000 pages of records for this guy. He was in the ICU pretty much the entire time. So the progress notes, the nursing notes, the vitals, all that stuff, as you know, in the EMRs, when they get printed nowadays, there's so many repeats and whatnot. So 30,000+ pages of records is what the defense had. Well, when I showed up to the first session of deposition, I was talking to the defense attorney, or one of the first depositions that was taken in the case. I was talking to the defense attorney about the records from Cedars, and I said, hey, can we agree that, of the 4,000 or so pages from Cedars-Sinai, that these 100 are really the ones that we need for the purposes of these depositions going forward? And he was like, what are you talking about? 4,000 pages of records from Cedars-Sinai. And I'm like, that's, my records authorization, my HIPAA authorization from the widow, I sent over to Cedars-Sinai before we filed, and Cedars-Sinai sent back with custodian of records declaration attached to it, surprisingly. Sent back 4,000 pages and some change. And he was like, Jason, there's like 33,000 pages of records in this case from Cedars-Sinai alone. And I was blown away. But that's not the first time that's happened. In fact, it happens a lot, it seems, in these cases. So my frustration is, I think some people are frustrated with EMRs and the fact that doctors seem to be losing the what used to be kind of an integral part of practice in medicine, which was creating good notes. The same thing's true for nurses. Now everything's just kind of auto-populate and drop-down menus, and you click this and it just plugs right into the note. That to me is actually, in my mind, I think that's good for plaintiffs' lawyers, because I think there's a lot we can do with that or lack thereof. My frustration is the fact that the defense is somehow able to get, complete sets of records that the plaintiffs can't get their hands on. And what stinks about that, and one thing your audience should know, and I'm sure that the people listening and all know this, those records don't belong to the hospital. They belong to the patient. This is the patient's medical records. Despite that, the patient has no input or say on what goes in that record. And when they do try to get their hands on it, the hospital gets in the way of producing a complete set because of either costs or if they're trying to hide something or otherwise. So that to me, that whole industry started to go down a path that is not good. And I don't know how to fix it.
Yeah, not incomplete records. Yes, I understand that's a pet peeve of mine.
Yeah.
Definitely. And you have given so much good information here today, Jason. And I'm just trying to see if there any more, something you haven't covered yet, something you want to share with those veteran or newbie attorneys out there when they're deciding to take these cases or not to take them or pass them on. What any other juicy advice you have for them?
I think for someone who's never handled a medical malpractice case before, I think it's, unless you can get the case resolved in pre-litigation, which 9 times out of 10 you can't do in a med mal case because most states require the physician's written consent to settle the case before the case gets resolved. But if you can't get the case settled in pre-lit, I think it would behoove you to associating counsel who's had a history of handling these cases, not only from filing to mediation, but also through trial, because it's not until you actually see these cases get tried or try them yourself that you really understand how to separate the wheat from the chaff. And if someone asked me to handle a workers' comp case, let's say it was a close friend, the first thing I do is I pick up the phone and I'd call a few lawyers in the area that I know who do workers' comp and ask them to work with me through the process so that I could, 1, be the point person for my friend, and 2, also learn how to do it. Well, same thing's true with med mal. It's so unique and so specific, and the lawyers that the insurance companies hire to represent physicians and hospitals are so good that you'll get smoked if you don't know what you're doing, because it's not just litigating the case from start to finish or producing your client for deposition. You also have to know who to hire in terms of expert witnesses. And your expert witness selection sometimes can be the driving factor in getting a case resolved. And that was true in a case, plastic surgery case that I saw recently. The case resolved because of who my expert was. The defendant knew him, not on a personal level, but on a professional level, really respected his work and was like, shoot, if that guy's critical, maybe I really ought to rethink, how it is that I'm doing this. And we got the case resolved. So, if you don't handle med mal and you don't have a well of experts and resources that you can kind of call on, and you're just kind of hiring people off of experts.com or whatever the heck it may be, you're going to get burned. And these cases are not cheap. I mean, we settled a case when I was still with Sean Burke, and we settled a case last year where Sean had, close to $300,000 in costs in the case. So it's an expensive genre of case to prosecute. It's difficult to find the right experts, and the defense attorneys are really, really good. So if you're kind of a novice in the area, I'd recommend that you co-counsel with someone in terms of veteran lawyers. I don't know how much I have to offer them. I've been practicing for 11 years. I'm a few trials away from becoming eligible for a VOTA. Fingers crossed I get the nod there soon. And all I can say to veteran lawyers is just keep filing cases and keep trying cases, because that's how you learn, right? I mean, I'm very fortunate to be a part of a group of older lawyers who have been practicing med mal for a very long time, where I get the benefit of their collective experience and knowledge through a kind of like a listserv group sort of thing. There's, I think, 30 plus lawyers in that group. And then there's also a kind of a parallel version of that, but for lawyers under the age of 40, that myself and another buddy of mine had started. And, that we learn more from taking cases to trial or arbitration, sometimes losing, than we do just not, doing anything with these cases or just passing on these cases, right? Because there's, in California anyway, a cap on general damages, which is going to increase after next year, but nonetheless, a cap on general damages. In addition, up until next January, there was a cap on the amount of fees that you can recover in these cases, and it would go down the more you recovered for your client, which is great for the injured patient. I personally don't have or take offense to the fact that my fee would go down the more I'd recover. But that legislation, which was passed in 1975, was passed solely as a means to disincentivize lawyers from representing victims of medical malpractice in the state of California. Over the last 45 years, what's resulted is, unfortunately, folks who don't have a significant economic damages claim, have not been able to find good quality representation to take their case, because from a business standpoint, if you have to spend $75,000 in depositions and expert witness fees to only get $250,000 at the end of it, that's not a great proposition to be in. So, my hope is that after next year, more folks who've been victimized as a result of medical malpractice will be able to find good quality representation in light of the changes to MICRA. And I hope that younger and veteran lawyers alike just continue to get better and sharpen their skills in this area, because the defense attorneys are exceptional, and we've got a big road to hoe when prosecuting cases against them.
All right. Well, that sounds like very good information. And Stephen Haber, who is a veteran attorney, says you have very good and salient points. There you go. You can always depend on Stephen Haber for some good input. So there you go. Well, it looks like it is around the time where we have a little Q&A time in our show. And are you ready to answer some questions?
I am.
All right. Well, while people are getting together their questions to slip into this comment box over here, and so we can ask you those questions and they can get answers. While we're waiting for you to get those questions together, it's time for what I call a small sponsor break, where we tell everybody what we do here at Wade Nurse Consultants. And without a review and summary of the medical records, it might be harder for you personal injury and med mal attorneys to know if you should take that case. And here at Wade Nurse Consultants, we give attorneys a 1 to 2 page synopsis and opinion regarding the merits of their medical cases, by using my 30 plus years of nursing experience to make quick work of those medical case screenings. So if you're watching this and you already have a nurse paralegal on the payroll, this isn't for you. But if you have a backlog of medical case screenings to get to, here is what you need to do right now. We're offering a free 20-minute medical record strategy call in order for you to hone an efficient, timely, and cost-effective routine around your medical cases. And inside the description box of this YouTube channel, you'll find a link where you can click and schedule a consultation. And now let's get back to Jason Argos for a little Q&A. All right, guess what? Wait a minute. What computer? Oh, we do have a question. I'm not sure who it's for, though, but let's find out. All right, Stephen Haber, what platform do you use for case management and record storage review? I think that's for you, Jason.
I'm looking at the comment section. We use Clio, Stephen. And then Clio works with Microsoft OneDrive for our kind of database storage, cases, etc. In fact, I can show you. Let me show you what that looks like.
Oh, I don't know if you can show us. I don't know if I can get you to share. So I don't know. I don't. Maybe we're gonna do some. Oh. Let me see if I can add that to the stream. Hang on. Let's see. Ta-da.
There we go. Yeah. So that's what our case names look. I mean, those are our case names, but that's what our system looks like. So,
Right.
So yeah, it all works in there.
All right. There you go.
Yeah.
All right. I'm checking for any more questions, but I don't see any yet. And I do have one question for you.
Yes, ma'am.
Will you come again and be part of our show?
Of course. And I'd be happy to, I don't know if I don't know if you've considered it or not, but I'd be happy to jump on with another lawyer too, who does this on another, on the other side of the country, just because I think we have a lot to learn from practitioners who are doing this in states without caps on damages, right? Or in other states where there are caps on damages in medical malpractice cases, or experts that they've found to be effective. I'd be happy to come back and like I said, would be happy to kind of tag team the presentation with another lawyer from a different part of the country.
Well, excellent. Well, we'll send Stephen Haber a message. He is on the exact opposite of the Stephen's in New York, so he's interested. So maybe we'll have you and Stephen tag team in 2023.
That'd be awesome.
Let's think about that. Oh, that sounds good. Well, Stephen, if you're up for that, put a yes in the chat. And what's going to happen is I'm going to put Jason Argos's contact information in the description box of this YouTube channel. So feel free, everybody, to just dive in and ask as many questions of Jason and reach out to him at his contact his email, and he'll get back to you. Does that sound like a plan, Jason?
Good by me.
All right. Excellent. And somebody, Liz took notes. She enjoyed your presentation. All right. Wait a minute. Okay, here we go. Liz is another LNC. Thank you, Jason. I'm learning how attorneys think so I can better assist them as a legal nurse consultant. Well, that's what I'm doing every week, Liz. Yay.
Lisa, I will say too, just before we close here, that I know several firms who have LNCs in-house, and several firms who have that, they send that work out. I can't speak highly enough about legal nurse consultants. I don't have the luxury of using one right now, but I have used one in the past and found a lot of benefit out of it. So if there are firms who are considering that or on the fence about that, I'm pro legal nurse consultant in every way, shape, and form. My practice right now, it's like I mentioned earlier, the strike zone's so small. I'm not carrying 90 medical malpractice cases, right? I'm carrying more like 15. So if you have a big, high volume med malpractice, which I came from on the way here, I'd certainly recommend hiring a legal nurse consultant.
I think that's excellent advice, Jason. It's one of the best things you said. Well, thank you again for being here, sharing all your wonderful insights. And I think we're winding down for right now. And I thank you again for coming. Let me just remind everybody out there that's watching us live or on the replay, this show, subscribe to this channel, this YouTube channel, Lisa Wade LNC. And if you have any questions for me, any legal nurse consulting questions, feel free to reach out at lisa@wadenurseconsultants.com. But tune in next week and catch us Monday, 5:15 p.m. Eastern Standard Time for a brand new episode of Should You Take That Case? Thanks again for coming.
Thanks for having me.
All right.
Thanks for watching and listening to another episode of Should You Take That Case with your host, Lisa Wade, your friendly neighborhood legal nurse consultant, owner of Wade Nurse Consultants, and creator of our private LinkedIn community, the Attorney Medical Record Resource Group. That is where we get all of our stellar attorney guests. The goal of our show is to be a resource for legal professionals who pursue medical cases by sharing their experiences and insights as defense or as plaintiff attorneys. You can catch prior episodes at www.wadenurseconsultants.com/blog, on LinkedIn, and on Apple Podcasts, Spotify, Google Podcasts, and more. Thank you for subscribing to our YouTube channel and sharing this show with others.